Okay, so in a perfect world, when you have an express easement in a document, the parties are conscientious and specify the location and the dimensions of the easement. Well, that's kind of how it works in modern times. People weren't always so concerned about this. People weren't always so litigious about this. And if you look at a lot of older easements, you have real sort of general grants that don't tie the right or the easement to any particular part of the property that's burdened. So the question then becomes, well, what am I allowed to do as the easement holder? Do I have the free run of the whole property or not? And that kind of easement is called a blanket easement. It applies to the whole property. And the general rule is that yeah, you may have an easement over the whole property, but there's got to be a sort of rule of reason in terms of where you actually end up putting a line. And the rule is that generally you have, as the property owner, you've got the right to select an appropriate location that meets the needs of the condemning authority or the dominant estate holder. But if you don't do that, and usually you wouldn't because you probably wouldn't know that as a property owner, you know, the AEPs or the First Energies or Marathons of the world will come in and say, hey, we want to put it here, you know, we've got this blanket easement. Are you okay with that? And, you know, or maybe not quite, are you okay with that? But that's how it's going to be. And if you want to stop us, well, good luck. So, you know, as long as they select a location that's consistent with their rights under the easement, that's permissible. Now, once the dimensions and the location have been established, the parties have decided one way or the other where it's going to be, that's where it is. And it becomes fixed in that location and to that size by what we call use and acquiescence. And that's, as I'm talking, I'm realizing that in the formatting for this presentation, my fancy black letter law font got thrown out the window, but that's black letter law, that first bullet point, and all these points I've been talking about are. But then we had this case in 2014 from the Ohio Supreme Court, which kind of undercut that principle a little bit, because that was a situation where they did let the dominant holder move the location of an easement, you know, over the objections of the property owner. So it's a little, I think I would still say it's black letter law in most cases, but it's going to be a fact by fact or case by case analysis based on the facts of each case, based on this Wasserman case.